Next, we have Stephanie Brown, followed by Jack Baez. Good morning again, ma'am. We're here today for a first appearance on the new case and bail hearing on both of the cases. Probable cause had been found in that new case of RPC 2023-053-845. As I indicated previously on the record, you do score according to the Nevada pretrial risk assessment as a 1, which is a low risk. And the public defender's office has been appointed to represent you in both cases. State, are we ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, the state's going to be seeking bail in the amount of $100,000, and we're asking the court for a no 10% cash option. As the charges stand right now, that's not required under the administrative order because there is no category B. However, in reviewing the charges, I can tell the court that it will be charged with category B offenses, and that's why we're asking for the no 10%. The state believes—
Just for the record, sorry to interrupt you, but just for the record, can you say what those category B offenses are, since you're requesting me to go outside of what is on the PC sheet?
Yes, Your Honor. The state will be charging the assault with a deadly weapon, this defendant as an aider and abettor in that crime, which, as the probable cause outlines, she participated in by handing the gun to the child in this case, who then shot the weapon towards the victims. So she'll be charged as an aider and abettor there, and she will be charged with felony child endangerment based on, again, those same factors, which will also be a category B offense. This case is interesting. There's right now, she has a lot of charges pending. The search warrant produced more evidence than what we saw yesterday. Obviously, the assault with a deadly weapon charge is very concerning to the state. We have minors involved. We have the defendant's son involved, in which I just spoke about her providing the weapon to him and them shooting at these minor juveniles. And in addition to that, when the sheriff's office goes back to the residence, they do get a search warrant and search the house, and they find these 66 different weapons, most of them in the room of the juvenile child. You can see that the defendant makes statements in regards to, I don't know how to get in. They were all in a gun safe. I don't know how to get in there. Those are the juvenile's guns. Part of those weapons were short-barreled shotguns below the legal limit for the barrel. In addition to that, one was considered or could be considered a machine gun, which is the basis for one of the charges, the category D charges, which is illegal in the state of Nevada. Most concerning to the state and why the state is asking for this high bail is the state certainly believes this defendant does pose a risk to our community. As stated, she aided and abetted her son in the production of a firearm and shooting in a neighborhood. There's clearly an ongoing dispute with this other family who lives apparently very close to them. And just the discretion, the character of this defendant that the court can consider is definitely at issue, where you see not only is she not parenting this child, but she's actually aiding and abetting, assisting him in committing crimes. So all of that is very concerning to the state. The number of weapons, in addition to finding the marijuana in the juvenile's room, bags of it on the wall, pipes in the juvenile room. Again, this isn't just a passive parenting case. This is somebody who, again, knows exactly what's going on in their house, is aiding and abetting even in that crime, allowing the juvenile to smoke marijuana, in addition to having these numerous amounts of weapons, ammunition, magazines, grenade launcher. Again, the PC is very clear about these facts. So based on all of that danger to the community, even with that low NPRA score, she has one 2013 violation of a domestic battery TPO charge that was dismissed. So she essentially has no criminal history, but the egregiousness of this offense, I think, demands some type of bail for the safety of our community. And so based on that, we're asking for the $100,000 with no 10% cash option.
Any other conditions?
Yes, we would ask for DAS supervision. We would ask for no drugs and alcohol based on what was found in the house. We would ask for no contact with the juvenile, Spencer. I know he's currently in custody at Jan Evans. I don't know how long he's going to be there, but I think it's absolutely appropriate that she have no contact with that child. And no firearms clause whatsoever.
What about the other minor children?
Well, it's kind of interesting because the second probable cause sheet, I thought it was going to talk about these same 5 children. It doesn't mention them. So she's not going to be charged, or she wasn't arrested on those charges for those other children. And it's not super clear if those kids were home or what was going on with those kids. So at this point, I don't know that I have a basis for those other children.
And do you have any information regarding whether or not CPS is involved?
They are involved, Your Honor, yes.
Thank you. And then just for the record, since you are asking a very high bail amount for an individual who scores as a 1, can you please provide some more information for the record as to that specifically for that amount? I'm assuming, and I just don't want to make assumptions, but is it just based off of the nature of the charges, what they found, what was found? So if you could please just provide some more information.
Yes, Your Honor. I mean, I think it's based on the amount of charges, the penalties that she's going to face, which are prison penalties. It's mandatory on one charge, the child endangerment felony, unless she can prove that she is not a risk to reoffend. So that's one of the reasons. But mostly it's the danger to the community. We have, obviously, you can tell by the probable cause declaration, is this entire incident, it surrounds this ongoing feud between these 2 families. There absolutely is a danger to the entire community of Cold Springs. We've got shooting in the middle of the day with kids walking around. I think, and again, while this defendant didn't pull the trigger, she certainly participated in it, knew that the weapons were there. And again, I hate to say it's lucky, but it's lucky that this occurred and that the sheriff's office did a search warrant, found all those weapons in this child's room. We don't know what would have happened down the road. So all of that points to a higher bail because she is a risk and a danger to this community.
Thank you. And then just to confirm, are you requesting for this court to issue 1 judicial release order that includes both of the probable cause sheets for a total of the 100,000?
Yes, Your Honor. I'll be charging the case today, and I'll be combining both of those probable cause sheets together.
Thank you. And I did not hear you ask for a no contact order with the named victim in that RPC 2023-053834 sheet.
Was that the juvenile?
Correct.
We would absolutely ask for a no contact with that juvenile as well, Your Honor.
Thank you. Defense?
Thank you, Your Honor. Understanding that this is a complicated scenario of circumstances, we would ask that the court OR Ms. Brown with conditions. It's my understanding from reading, I believe it's in the probable cause that the weapons were seized from the home, that the juvenile Spencer is detained at Jan Evans. And certainly Ms. Brown has a lot to figure out regarding many circumstances, these charges, as well as the involvement with Child Protective Services, that will be sorted out. But at this juncture, there are no firearms in the home. She would absolutely be prohibited from having any firearms in the home or any controlled substances. Could be on enhanced supervision, check in with DAS. They could certainly search the home at any time. And again, there's also the Child Protective Services also will have access to the home. We anticipate protective custody will be granted tomorrow. So with those enhanced protections, we would submit that Ms. Brown is not a danger to the community. Again, she scores a 1 and could comply with any supervision requirements in order to mitigate future risk to the community.
Thank you. And Ms. Reigns, just so I have the information. So we do not, DAS does not have what we like an enhanced supervision anymore. So are you stipulating to what previously was enhanced supervision in terms of requiring drug and alcohol testing?
Yes, we would stipulate to any conditions that would satisfy the the court and the state for community safety purposes in order for Ms. Brown to be released into the community.
Thank you. And you indicated that DAS could conduct, in essence, home visits. That's unfortunately not something that is authorized by DAS. They do not have a search and seizure clause as she is on probation.
Yes, my error, Your Honor. So I withdraw that. I misspoke. That would be a condition of probation, which of course would be premature at this juncture. So whatever options are available to protect the community, she would be willing to comply with. But again, it's my understanding that the weapons were, during this search and seizure, that all of those weapons were seized from the home.
Thank you. Ms. Brown, this is a very tough case for the court, as the facts and circumstances as alleged are very concerning, as well as the numerous amounts of guns that were located allegedly in the home. I will note that there was some discussion regarding speculation that we don't know what it could have happened. Just for the record, I'm not considering that in determining my order here today. However, I do find that the state has proven by clear and convincing evidence that some bail is required and appropriate in this case, despite the fact that you do score as a 1 on the Nevada pretrial risk assessment. So I will be setting bail. It'll be bail in the amount of $50,000. That will be bondable with no 10% cash option. I will be imposing a no contact order with the named victim in this case. I am also going to require that you be subjected to residential confinement. That is the basis for, in essence, I'm reducing it from the amount requested by the state. If I do find that that is necessary, it doesn't indicate that it is a least restrictive means that would allow me to grant you no recognizance release, but I do find that that is necessary and appropriate in determining a bail amount. So I am requiring that you be subjected to residential confinement, where a GPS monitor will be installed on you prior to release, based on the stipulation of the parties, as well as the allegation contained in the probable cause sheet. I will require that you do not use any controlled substances or alcohol unless you have a valid prescription. That includes medical marijuana. You cannot use medical marijuana if you have a prescription. You'll have to provide that to the court and go through appropriate motion work with your counsel in order to determine whether or not that would be permitted. You can also not possess any firearms or weapons there is an allegation of a crime of violence, and so you cannot possess any weapons or firearms during the dependency of this case. You also must comply with all conditions set forth by the Human Services Agency or CPS. In case I did not say it, as I indicated, there will be a no contact order with the named victim in this case, as well as the no contact order with your minor son, Spencer. And I am requiring that you be supervised by the Department of Alternative Sentencing. So you are required to check in within 24 hours of your release. And I am going to set a 72-hour hearing, and that will be set for July 7th at 9:30 a.m. Thank you.
Mhm.